Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. This week, we're talking about copyright protections. We're going to talk about how to obtain them, how to avoid getting in trouble with them, and what to do if you do get in trouble with them. So we're going to go ahead and start with copyright protections, how long, what is covered, and strategies for registration. So a quote here, copyright is not only the legal foundation for the music industry, it is also the foundation of the film, software, publishing, and many other creative industries. That quote's from David Israelite. He's the president and CEO of the National Music Publishers Association since 2005. So this podcast is for small businesses. How does this apply to you? Even if you are not in one of these industries with copyright as their legal foundation. Well, I have some questions. Do you create content? Do you have a website? Do you have any software that you've created? Are you creating manuals, procedures, or other content with some level of creativity that you might use internally with your business? In my law firm, Inspired Idea Solutions, we focus on helping small businesses to own their IP. This is often a challenge with copyright, not because it is hard, but because if you don't take simple steps, in many cases, you do not own the copyright. So we're going to talk about, when we talk about copyright, one of the words we use is work or works. That's short for a work of art. Now, the copyright definition of art or work is going to be broader than what most people think of art. So, for example, copyright law protects software, and we don't usually think of that as art, but copyright considers that art. Anything written is considered under that works or works of art definition. So what does copyright law protect? It protects creators. It protects their creative content, the content they themselves create that has creativity and it's original. And the most important thing for a business owner to know, as I mentioned before, is that you may not own the copyright just because you paid someone to create something, even if they created it from scratch. I'm not talking about, oh, they borrowed this or they took that. That's not the issue. You might not own the copyright, even if an employee creates it, or even if a contractor that you paid creates it. So first of all, I want to go over the definition of work for hire. Most businesses think if they paid for it, it's a work for hire and they own it. Well, that's not necessarily true. There are two ways to qualify for a work for hire. The first one is it has to be a work prepared by an employee within the scope of his or her employment. That sounds pretty simple, but the question is, do you have job descriptions? And the person who created that is creating content within their job description. And if it's not, then it's probably not a work for hire. So what can you do? Well, you can have a good contract in place with all employees, making sure that anything that they create for the business, even if they go outside of their scope of work, their job description is still owned by the company. So the second category is a work specially ordered or commissioned for use, but it has to be in one of these 9 categories: a contribution to a collective work, part of a motion picture or audio visual work, so some kind of film, as a translation, a supplementary work, a compilation, an instruction text, a test, answer materials for a test, or an atlas. Now, most of these are not what businesses are creating when they create content, when they have somebody put together a custom website or even a template website. So if that's a contractor, and in a lot of cases it is a contractor, then the contractor owns the copyright. And so is that a big deal? Well, oh, and one more thing is, it doesn't just have to be paid for and in one of those 9 categories. It also, you have to have a written agreement that expressly states it's a work made for hire. So I have agreements I prepare that make it clear that it's a work made for hire. And if it doesn't qualify as a work made for hire, they're still assigning the rights to the business. So let's talk about what the copyright's rights are. And if you don't own these rights, it can be a challenge. The copyright can be used against you. It can also be a challenge when you're trying to sell your business. For example, if you have developed an extensive website and that's the core of your business, nothing's going to function in your business. You're not going to sell a thing without that website. If you don't own the copyright of the creative content, what's been put into that copyright or into that website, you may not have a very good basis. When someone goes to buy a business, if they're smart, they're going to do due diligence, and they're going to try to find out, do you own the necessary copyrights? So what does the law give the copyright owner? It gives them the right to control any reproduction, to make copies of their work, and the exclusive right to make derivative works. Anything that is derived from the original art or work is a derivative work. For example, the Harry Potter movies were derivative works from the Harry Potter books. J.K. Rowling can sue anyone that makes a Harry Potter movie or even writes their own Harry Potter book if it's derived from their books. If they're using the name Harry Potter, that probably is. Now, just a side note, fan fiction is usually technically infringing on the copyright, and whoever owns that copyright can choose not to enforce that, or you can get explicit permission. For works that can be performed, the owner has the exclusive right to control who publicly performs that work. For example, something that can be sung, read, acted, etc. Now, for visual works of arts like sculptures, paintings, the owner has the right to control how the work is publicly displayed. Additionally, for visual works of art, the author or artist can sue if the art is used in a way that they consider offensive or harmful to their reputation, even if they've sold the copyright ownership. This happens sometimes to museums who are creating a big exhibit, and they've hired somebody to come in and create this exhibit. And then they get into a disagreement before it's finished. And the museum goes ahead and said, well, we're going to go ahead and, exhibit this. We're going to finish it ourselves and exhibit it. And then the artist sues and said, I don't care that you own the copyright. Per our agreement, you don't own what's called the moral rights or the control rights for then the reputation rights to this. So that's one other thing to look out for if you're having visual works of art created. So just some of the things that it protects are videos, photographs, recorded songs, sheet music, novels, sculptures, paintings, software. So anything that has creative content that can be reproduced, it's probably going to be able to be eligible for copyright. And the creator automatically owns the copyright as soon as it is created, or what they say, fixed in a tangible medium. If it's on a hard drive, that's tangible. Somewhere where it can be reproduced. They write it down on paper, that can be reproduced. It can be copied. So the copyright ownership is automatic as soon as it happens. Now, the question is, who is it automatic for? Is it for the business or is it for the individual? The default is the individual, and you have to prove, oh no, this is actually supposed to be in this business. So if you don't have things lined up properly, you might not be owning that. And the length of copyright, well, it generally lasts for the lifetime of the author plus a set number of years, which in the United States is 70 years. So an example, a 20-year-old student takes an amazing once-in-a-lifetime picture. She will own the copyright as the creator or artist. And if she lives to 100 years old, then the copyright expires 70 years after she died. So the 80 years after she took the picture and the 70 years after she died is 150 years after she took the picture. Works that are made for hire, published pseudonymously, anonymously, those are 95 years from publication with a limit of 120 years from the date of creation. So if film clips, like what gets left on the cutting room floor, are not published and 30 years later they get published, then it won't be 95 years from that publication date because they've already burned up 30 of the 120 years. So there's only 90 years left. So what do you register? Copyright registration is not required for claiming copyright, putting the copyright notice with the circle C. So you don't have to have that registered, but a registration is required for a lawsuit in federal court. So one of the most important things to understand about why to register is if you register a copyright before it's infringed, you can get statutory damages. That's $750 up to $150,000 per copyright work and your attorney's fees. If you register the copyright after it's been infringed, you only get provable damages. And it's often difficult to prove how much you were harmed by someone copying that. One other thing, for when you have multiple works, you can often, there are certain categories where you can combine things together that you're producing on a regular basis and make them into one copyright. So we're out of time for today. I'm Wayne Carroll with Leveraging Inspiration.